Hi, good evening to one and all. Today we'll be starting with share and share capital, the most important chapter of company law. Now, while starting, let me tell you what all documents I have with me. One is the ICSI study material because everything comes from the study material. So I will be giving you all markings, what is important from exam point of view to cover this entire chapter, this massive chapter. Second, with me, I have the past exam questions for the entire company law scanner which I have made. So I will be taking you all through the past exam questions as well. Third, I also have a few other forms etc. which I will be taking you all through the documents. So are we good to go? So just give me a thumbs up so we can quickly start. Am I audible and clear so we can quickly start? Just put in the chat box. Am I audible? Just waiting for you to put in the chat box whether I'm clear and audible and visible or no. And I want you all to go and get your modules, ICSI modules, from which I will be taking you all through this entire chapter and make it very simple for you. Okay, so I'm just reading in from the chat box. Okay, great. Okay, great. So let's begin with the chapter. Okay, so share and share capital. During the entire lecture, I will be giving you all the important markings which you all can take, and from there mostly the entire paper should be set. First, when we start, we're talking of share and share capital. So what do you mean by the term capital? Capital for any business means funds, and funds for companies could be in two forms. One, it could be own funds, that is equity capital where the owners get their own funds, or it could be borrowed funds. When I say borrowed funds means you've taken a loan. This loan can be taken from banks, financial institutions, or can be taken from public in general called as debentures. So from here, what is important just to understand that here when we are talking of capital, we are talking of the share capital of the company. Next, now what is share capital and what are the various parts of it? This you can mark it as important because 2 marks, they might ask you one terminology for sure. And also, I will be taking you all through some of the practical experiences which we have delivered to companies and we have encountered in our CS profession. Now, the very first is about what do you mean by the term share. So all of your important sections I want you all to take and write it down with me. Okay. So the very first thing is, what do you mean by the term share? Okay, so you can take the section number 2, subsection 84, which defines what do you mean by the term share. Share means a share in the share capital of the company. So let's understand this term share. Okay, first, this is the entire funds of the company. This is the entire funds of the company called as capital. This capital can be divided into various parts. Okay, so this could be divided into various parts. Now when you take only one unit of it, it's called as a share. So what is a share? A share is a small unit or small fraction of the entire share capital of the company. So very, very important definition. This they will never ask you, but you need to quote in the exam along with the section number. Second, they have asked, now they will start with few things such as authorized capital, nominal capital, registered capital, issued capital, subscribed. Now let's understand what this terminology is. Okay. Now under the company law, whenever we incorporate companies, we ask the client what will be the share capital of the company or what share capital do they want to keep. According to what is the maximum amount, that is the authorized capital, they have to pay the stamp duty. So authorized capital, okay, is the maximum capital that the company can borrow or can raise from the public. So what is this? This is the first one, authorized capital. Okay. So what do you mean by the authorized capital? Authorized capital is written in the company's prospectus as well in the memorandum of companies, where they say that this is the authorized capital, is the maximum amount that they can raise. Tell me today, if companies want to raise more amount than the authorized capital, can they do that? I want you all are company secretaries. Can a company raise its authorized capital? If the authorized capital is given as 10 crores, can they do something by making some form filings? Can they increase their authorized capital? Yes or no? So very good. Answer is under section 61 of the Companies Act. It talks of alteration of share capital, where you can file SH7 and increase the share capital of the company also. Okay. Now, what is the share authorized capital? It's the maximum amount that you are allowed to raise from the public. Now, next thing. Let's say the authorized capital is 10 crores. Authorized capital of the company is 10 crores. Okay. Would the company need this 10 crores all in one shot? Answer is no. If I permit you to take a loan of 10 crores, will you go ahead and take a loan of 10 crores? Answer is no. This is the limit that they have given you. Within that limit, you can use. So let's say the company plans to issue shares worth 8 crores only. This is the issued share capital. These many shares the company is floating in the market. This is called the issued capital. Now, if the company is planning to sell its shares, issue its shares, you think it will always find buyers in the market? Answer is no. So if the issued capital, if the company is issuing shares, selling shares worth 8 crores, it is possible that it's not fully subscribed and only the subscribed portion is 7 crores. Yes or no? So the biggest is authorized, below that is issued, below that is subscribed. Now when they subscribe, so there might be people who might have come forward and subscribed to 7 crores, okay, worth shares. Now further, when the shareholders have subscribed to 7 crores, you think company will call the entire amount in one go? They definitely can call, but it's not necessary. Company can call this amount in calls, various calls, first call, second call, final call. So even though public have subscribed and are ready to pay 7 crores, it is possible that the company have called up a certain amount, let's say 5 crores. Now imagine if you ever made a call, a demand that pay 5 crores or pay 5 crores, you think always people are going to pay up? It's possible that some people might not be able to pay or have defaulted in paying. So then the last concept comes to paid up capital. It comes up to paid up capital. Paid up capital, if you have seen in Companies Act, many times they use the word paid up capital, and this pays the biggest importance in company law. Why? Because this is the amount that's actually hit in the company's pockets. They actually have 4 crores in the account because that much has been paid by the shareholders to the company. So the paid up capital is a very important factor to figure the net worth of the company. Clear? Moving forward, so these terms, they might just ask you have to go through it for 2 marks. Then comes equity and preference. So shares in the company. Okay. Now I know for sure that all of you all will be able to tell me that there are 2 kinds of share capital. 2 kinds of share capital, that is equity shares and preference shares. Okay. I'm sure all of you all can do that. But can any of you all tell me in which section number this is written? Under which section it is written that there are two kinds of share capital, equity shares and preference shares? Can anyone put in the chat box? Waiting for it. Okay, perfect. So the answer is under section 43 of the Companies Act, it stated that there are two kinds of share capital, equity and preference. Now imagine if I have to gift you, okay, for your love and support, I want to gift you a share. Would you want equity shares or do you want preference shares? Which shares do you all want, equity or preference? Obviously you would ask for preference shares. Why? Because preference shares has preference over equity shareholders in two things: when they are paying dividend and at the time of winding up of the company. So preference shareholders enjoy preferential right, priority right over equity shareholders at the time of payment of dividend and at the time of payment of at the time of winding up of the company. Perfect. Okay, moving forward. Now there is one more concept where equity shares could be with equal voting rights or with DVRs, differential voting rights. Now this differential voting rights is a very interesting concept. One is with equal voting rights or same voting rights, and the other one is with DVRs, differential voting rights. Now tell me one thing in the chat box, do you know the concept of DVR, differential voting rights? Okay, now that is also given under section 43, obviously in rule 4. Differential voting rights is where there is the voting rights are not the same. Now there are certain conditions. Now in practical life, I have dealt with DVRs also, where it might not even be given in your books, but let me give you some knowledge on it, okay, on the practical side. When we say differential voting rights, means all the shares might have one share, one vote, one share, one vote, right? One share, one vote. A DVR could have one share, two votes. This is a DVR, differential voting rights. So in the practical side, what I have observed that it's not only voting rights, but if you read section 43, when they talk of DVR, they also say any other differential rights. For example, okay, now just pay attention. This I'm taking you all through some practical aspects which is not given in your module. For example, we know that at the time of winding up, preference shares are paid first and then equity shares, right? Yes or no? First preference shareholders, then equity shareholders. Now there was an investment agreement where we were dealing, where what happened is the investor said that give us DVR equity rights. We don't want with respect to voting. Voting can be same. We want extra voting, extra rights with respect to winding up. So we will get first preference at time of winding up, and only if the investor's money is paid off, those rights are paid off, then the other equity shareholders will get the money. Okay, so this is also a differential voting right. It's called as DVR, but DVR could be for other than voting rights also, as long as there is a variation from the normal terms. So in that, what happened, the investor says, I'm giving you so much money, I'm investing so much money. If at the time of winding up, first my right should be taken care of, then money is left, then you all can distribute among yourselves. So similar points were there. Okay, so we will be coming to DVR shortly. Now we will complete it from how they have given it in the flow of the module. Now they said publication of authorized, subscribed and paid up capital. Publication means what? Tell me one thing, can I only talk about my assets and not about my liabilities? I only talk about good things about me but not the bad things. Is it okay? Can a company just talk about their authorized capital, issued capital but not the paid up capital? So they say no, wait a minute. If the company at any time as per section 60 announces, publicizes, displays advertises its authorized capital, it also has to say what is its paid up capital. So let's read the sentence. Now this is not important, but we'll just read it across. Okay, what does it say? It says where any notice, advertisement, publication. So where any notice, advertisement, publication or any business letter, anything contains a statement of the amount of authorized capital on such notice or advertisement or official publication. So if it is containing the amount of authorized capital, then also say the other forms of capital. Then the same letter shall also contain in a equally prominent position. So it should not be in the small little letters in the side. It should be in the same position, equally prominent. Prominent means clear position, in equally conspicuous characters, in clear characters of the amount that has been subscribed and paid up. Is the concept clear? That whenever a company advertises, issues, publicizes any document which contains the authorized capital, it should also include in same position, that is you're in the same prominent position and equally conspicuous characters, the paid up capital and the subscribed capital also. Very simple. And if they don't do so, then they will be held liable for penalty of 5,000 rupees for each such default. Very, very simple. Let's move ahead. Share and types of share capital. Till now, I had told you all to remember one section which I want you all to proactively quote in the exam. That is your section 2 subsection 84, which we just did, which talks about the definition of share. Okay, which talks about the definition of share. Now, nature of share. Now, they have given you many points, but I will give you points which are important for you to know. Okay, and which can come in your exams. So wherever you see a section, that is important. So section 44 and 45 are important. Now what does 44 say? Now 44 is extremely important. Again, I want you to quote it in your exam. Now tell me one thing. Is share a movable property, immovable property or a intangible property? I want you all to put in the chat box. A share will be treated as a movable or immovable property. Perfect answer. So it will be a movable property. That's given in section number 44. That a share or a debenture or any other security will be treated as a movable property. So if it is movable, so what? So what if it is movable? So if it is movable, it is also transferable from one ownership to another person's name. So a share is also transferable and movable property. Section number 44. 45, what does it talk about? Every share certificate. Every share certificate. A share certificate is in which form number? Can you put in the chat box? A share certificate is in which form number? It is in SH1. A share certificate. A duplicate share certificate, that is in case it is lost or stolen, torn or defaced. So in case if the share certificate is lost, then the duplicate share certificate is issued in SH2. Okay, is issued in SH2. Now section 45 says that every physical share certificate should contain a distinctive number, that is a share certificate number. But this share certificate number is not needed in case of demat forms. Demat forms are nothing but electronic shares. Okay. Now coming to the types of share capital. Now this is a very general thing, very simple, which we just discussed, and I believe all of you all can tell with me under which section it is given, that there are two kinds of share capital, preference and equity. Equity can have equal voting rights, or very important, which comes in your exam, that is your DVRs. Differential voting rights. Now, preference shares. What do you mean by preference shares? Again, we discussed has preference over equity in two cases. Now the types of preference shares will come. Again, so as we discussed, preference shareholders will have preferential right over at the time of payment of dividend and at the time of winding up of the company. Section number 43 talking about preference shares. Also, I want you all to tell me, when we have these AGMs, etc., do preference shares attend those meetings? Those general meetings, do preference shareholders also attend the same meetings that we have in Reliance AGM, EGM? Yes or no? When I say general meetings, members meeting, do even preference shareholders go? Perfect answer is no. So preference shareholders do not attend meetings with equity shareholders. They have their own meetings where only preference shareholders will go, something called as class meetings. But there is an exception, and that exception is what comes in the exam, which I want you to know. In what circumstances, under what circumstances can preference shareholders attend the general meeting with the equity shareholders and vote on every single resolution that is put before the meeting? Which point of time can preference shareholders vote on every single matter that has been put up? So the answer is given when there has been two consecutive defaults. Okay, so here the answer is here, dividend. Now see, every member shall have a right to vote before the meeting. Now this is the point when we are talking section 47 subsection 2, that dividend in respect of class of preference shares which has not been paid for a period of 2 years or more, such preference share holders shall have a right to vote on all the resolution placed before the meeting. So for example, if preference shareholders were not paid dividend for 1 year, so they will be extremely sad, preference shareholders, yes or no? Again I tell, for the next year also, sorry, we couldn't pay dividend to you, there are no profits to the preference shareholders, no dividend only. So they are also shareholders, they are not equity shareholders, but they are shareholders. So then they will say no, for 2 years or more, if dividend is not paid, then the preference shareholders will come in the meeting and they will say what is happening. So this right is given under section 47. Now we're going to see types of preference shares. Now again, this is not that important, obviously it's not come in the exam, but let's understand what kinds of preference shares are there. Now preference shares are based on accumulation, are divided into accumulative and non-cumulative. Now what do you mean by cumulative preference shares? So remember, whenever I say the word cumulative, it comes from the word accumulate. So if dividend is not paid for a particular year, then that amount will be carried forward and it will accumulate to be given in the next year when the company has profits. Okay, so let's take an example. Let's say for some reason in 2022 the company could not give dividend. Okay, so the company could not give dividend, so all the shareholders will be sad. Then what happened is, the amount of dividend they used to give as rupees 20. So if you ever do sums on preference shares, you will see 8% preference shareholders or 10% preference shareholders. So we couldn't give that amount to them. So in the next year it will get carry forward and this amount will, along with the next year, will give 40 rupees. So this right of accumulation is there for cumulative preference shares. In non-cumulative, it does not accumulate and their right is lost. If dividend is not given in that year due to lack of profit, then they will not get in next year. It will not be carried forward in next year. So which one do you prefer to have, cumulative preference shares or non-cumulative? Obviously cumulative. That is why cumulative preference shares will be more expensive. Next, convertible means they can be converted into equity shares of the company. Non-convertible means they cannot be converted into equity shares of the company. Participating and non-participating preference shares. Now, what do you mean by participating? Remember the keyword surplus profit. What is the keyword? Surplus profit. So, in participating preference shares, the participating preference shares participate in surplus profits. So whenever a company, after distributing all the dividends, realize that there is still more funds available, more money available, then they will give it to the participating preference shares. Okay. Non-participating do not participate in surplus profits. They will not get extra money. Redeemable and non-redeemable. Now redeemable means what? Redeem means to repay. Now, when I say non-redeemable means it's not that they will not be repaid. A fixed date is not given or an uncertain event is given, such as winding up of the company. So, non-redeemable preference shares cannot be issued in India. Only redeemable, which will be repaid after a certain date or a specified date not exceeding 10 years, not exceeding 20 years in normal companies, and for infrastructure companies 30 years. So remember that maximum tenure of preference shares that can be there for issue is 20 years, and for infrastructure companies, since they are to make infrastructure projects, it takes time, it will be 30 years. Okay, now let's read section 55. Very simple. No company shall issue any preference shares which are irredeemable. Now what is this? Okay, now I want you to remember a particular section. Now since they have used the word section 55, so let me take you through a very important list of sections, that is your section 52, 53, 54, okay, and 55. What does section 52 talk about? That it talks about security premium account. Okay, we will see what is security premium and issue of shares at premium. So it talks about, I want you to write it with me so you can quote it in your exam, issue of shares at premium. Now if they're talking about premium, the very next section talks about issue of shares at discount. Discount is where they issue it at a lower price. Third, discount, and then they talk about sweat equity shares, where equity shares are being issued at discount only. Your last one talks about preference shares. Okay, so please make a note of this, it will help you in quote in your exams. And section 56 talks about transfer and transmission of shares. Transfer and transmission of shares and transmission of shares. Okay, all these sections are extremely important and to be quoted in your exam. Okay, now moving forward, equity share capital. Now very simple, this is not important from exam point of view. Again they have repeated section 53, certain characteristics of equity shares, not important. Section 47, I told you what is to be remembered in section 47 is that if preference shareholders have not been given dividend for 2 consecutive back-to-back years, then they will be getting a right to participate in every single meeting and vote at every single resolution as well. Okay, section 47, every member shall have a right to vote on every resolution placed before the company. Okay, so if you are a member of the company, obviously whatever is being placed, you will have a right to vote. Now coming to the concept, the part B, that is your concept of issue and allotment of securities. Okay, now first, chapter 3 of the Companies Act talks about prospectus and allotment of securities. Okay, now the most important section, now I will also take you all through some of the practical side of questions and I will see whether you know it or not. Okay, that is section number 23. Now section 23 talks about issue of securities. Issue of securities. Is this clear? Now issue of securities can be of two kinds. By they're saying what a private company can do and a public company. Okay. So a public company can issue what kind of securities and a private company can issue what kind of securities. Is this clear? Now, a public company can obviously make a public issue. They can raise money from the public, issue securities, debentures, etc. to the public, and they can also issue bonus shares or right issues. Okay, bonus shares is giving free of cost, right issue is giving rights to the existing shareholders to buy extra shares at discount. So right issue, which will also come, you're giving the existing shareholders a right to buy new shares at a discount. Okay, so public company can do that, and they can also do something called as private placement. Now from here, you all need to tell me what the private company cannot do. Private company can only do two things. One is it can do a private placement, yes, but what it cannot do, can it give bonus shares and right issue? Yes or no? Answer is yes. Only thing that a public company cannot do is issue shares at to public. Now let's read. Okay, a public company may issue securities to public through private placement and right issue and bonus shares. Whereas a private company can do only two things: private placement and right issue and bonus shares. For them, the third option of public issue is not there. Perfect. Now coming to the next thing, the term securities. Very, very interesting. If you see, and we had done a research for our client as well, where they wanted to say that it is written. I don't want to give you all. Let's see if you all will still understand a small what was the research about and why is this term security is very important. Okay, issue of shares is not given. Issue of securities is given. Securities is a wider term. It covers not only shares, it covers debentures, it covers bonds, it covers mutual fund units, it covers CIS units. So the term is very extensive. So what the client had asked us is, you all can tell me in the chat box, we've heard of right issue of shares. Can right issue of debentures be made? Can right issue of debentures be made? See, we had read section 62. 62 talks about right issue of, the word used there is shares. The client wanted to issue debentures and they are asking us under company law, is there any provision where we can make a right issue of debentures? So the answer is yes. You can read up even on Google, YouTube, you might not be able to find that easily. So in ICDR regulation, there is a clear provision that company can even make a right issue of debentures. So securities, since it is written that you can issue securities, and securities is a wider term. So moving ahead to section 81 of the Companies Act. Now can you all tell me what is the definition of share? Definition of share. So share is given under section 2 subsection 84 talks about share, whereas section 2 subsection 81 talks about securities. Okay, so remember this. And the funny part is when you go to read the definition under section 2 subsection 81, it will not give you the definition. It will take you to another act of SCRA Act and saying under section 2H, what is given under SCRA, go there. That is the definition. So let's look what it is. Okay. So section 2 subsection 81 means the securities as defined under clause 2H of SCRA Act. So Companies Act under section 2 subsection 81 defines securities to mean what is the meaning given under 2H of SCRA Act. So then I'm like, I need to now read section 2H of SCRA Act. So I go to section 2H of the Securities Contract Regulation Act, which it says that securities includes. So it's an inclusive definition. When I say includes means what? It is not, it is explaining that it covers this also, this also. So if you go to see, almost all kinds of units are there, but one kind of unit is excluded, specifically excluded, that is your insurance units. So it is clearly stated that securities shall not include any unit of insurance. So if I have life insurance policy, etc., that's not a security. Rest, if I see everything else, so shares are covered, government securities are covered, derivatives are covered, CIS units are covered, the SERFISI Act is covered. So now all this you don't need to know, but just these are all things that will come, you will come to know. Mutual fund units, your interest securities, any right securities, etc. The governing law is not important. Now we come to a very, very, very important topic, that's your prospectus. Extremely important. Almost every time there is a question framed from the prospectus segment. Now what do you mean by the term prospectus? What do you mean by the term prospectus? Now this you need to know with the definition under section 2 subsection 70. Okay, can a prospectus be issued to an individual? My question is, can a prospectus be issued to an individual? Yes or no? Okay, you all need to tell me, can a prospectus be issued in the to an individual? Answer is no. A prospectus is issued to public. Okay, so whenever I say prospectus, means it's a issue to public. Now let's understand the meaning of the term prospectus. Whenever I say prospectus, means it is a document which is issued to the public, asking the public to subscribe to the securities of the company. So prospectus states all the details of the company and it says, please subscribe to my shares. So any document, okay, which is issued as a prospectus includes red herring prospectus. We will see the type of prospectus under section 32, or a shelf prospectus under 31, okay, from the public for the subscription of securities of the body corporate. So a prospectus is a document which makes an issue to the public and inviting them to subscribe to your securities. Okay. Now they have used the terms red herring prospectus, shelf prospectus, and further they will use abridged prospectus also. So these three terms are very important and these have been asked in the past exam. So I want you all to know it properly as well. Section number 31, 32 and 33. Okay. Three sections you should know. Can anyone tell me what is section number 31? Can anyone tell me in the chat box what is section number 31? So why you cannot issue it to the individual? Because it is said that prospectus is a document which is issued to public at large. Okay. So now coming to what is section number 31, it is given in shelf prospectus. What is section number 32? It's a red herring prospectus, RHP that they call it. And what is section number 33? 33 talks about abridged prospectus. Okay, abridged prospectus. And what is the definition, under which section is the definition of prospectus given? Can anyone tell me? Definition of prospectus is given under which section? Section 2 subsection 70 gives the definition of prospectus. Okay, it's a document issued to the public, includes a red herring and a self prospectus, inviting the public to subscribe to the securities of the body corporate. Clear? So this is important. Please quote in your exams the section number that I'm taking you through. Now what is red herring and what is shelf, we will see in a short time. But the next important section is section number 26. Now obviously most of the time Now this I'm giving you from the practical point of view as a company secretary. While studying as a student like you, even I skipped this section number 26. I said it's not important, never come, just small little matters. What is to be stated in the prospectus is given. So it gives you that the prospectus should contain all the details, all the relevant details, all the disclosures, no material misstatement should be done, and that's it about the section 26. In practical life, I came to know that there was a merchant banker who got a penalty of 1 crore penalty for not complying with section number 26 properly. What was it? Let me tell you the scenario. So what happened is, there was a company which issued a prospectus and there was some material non-disclosures. So there were some non-disclosures that was there, that the license was earlier cancelled for the company, and that fact was not written in the prospectus. The merchant banker, the government, couldn't find that this is a fact that I had to put in the prospectus, and SEBI put a 1 CR penalty, 1 crore penalty on the merchant banker. So in practical life, this is the most important, because you have to see that the public has been given correct information, public has not been misinformed, public has not been deceived. This is very important. So after this, you should remember section number 26. You should always quote that the matters to be stated in the prospectus is given under section number 26. It should be true, fair and complete disclosures should be given. Next, coming to two important concepts. What do you mean by shelf prospectus and what do you mean by the term red herring prospectus? Now, shelf prospectus, what is the key word to remember? A shelf prospectus is a single prospectus for multiple issues. A single prospectus for multiple issues. Now, what does it mean? Okay, so here public companies who plan to come out with public issues very often, like 4 or 5 times in a year, 6 times in a year, they plan to raise money regularly within a short span. So every time to file the prospectus, get it approved from ROC, get it approved from SEBI is a long process. You have to give a draft prospectus, then they will approve, they will put in comments. Then so every time I cannot do, because in a short span I will go multiple times. So in that case, the company will come forward and they will say, this is a prospectus, take it. In this, I will get a validity period of 1 year. In this validity period, I can come out with many public issues. Clear till here? And I can come out without filing prospectus. Why? Because shelf prospectus is like a prospectus for multiple issues. So every time I go for a public issue, every time I don't have to file a new prospectus. Clear till here? So now let's understand what do you mean by shelf. Okay, shelf is you just keep it there, you keep it on the shelf. I'm going multiple times, you just keep seeing that same document. But very important, 2-3 questions. Can a private company issue a shelf prospectus? Can a private company issue a shelf prospectus? Obviously not, because it's going to the public. This shelf prospectus is available only to public company who within 1 year want to bring about multiple issues. Okay, so they don't have to file a prospectus every time they go. But you tell me one thing, do I have to inform ROC that I have gone? ROC should know that okay fine, I have given you a validity period from Jan to December, you can make multiple issues, you don't have to file prospectus. But at least tell me how many times you've gone. 4 times you've gone, 5 times I've gone, 6 times. At least that has to be given, yes or no. Should the ROC be informed of how many times they have gone in a year? Yes. So they have to file a specific form. Can anyone tell me what is the form number? And you actually have to inform them. That is called as an information memorandum. Information memorandum needs to be filed, which is in PAS 2 every time they go for public issue. Concept clear? Concept clear? Yes or no? Yes. So let's see. Now let's read from the book. Okay. A shelf prospectus means a prospectus which that securities in respect of offers for subscription in more than one issues for a certain time period without issue of further prospectus. So every time I don't have to issue prospectus. So in other words, it is a single prospectus for multiple issues. Now, and want to sell the securities to public without a separate prospectus for each such issue. Okay. Now under the Act, SEBI may provide may provide by regulation on this behalf, may file a shelf prospectus with the registrar and indicate a period not exceeding 1 year for the validity of such prospectus. So validity will be 1 year. So within 1 year I can keep going unlimited time, but every time I go I have to file information memorandum in PAS 2. Now this validity period of 1 year starts from when? From when does it commence? So it commences not from the time they have given me permission. It commences from the time when I have made my first issue. From that 1 year will be counted. So shall commence from the date of opening of the first issue under the shelf prospectus. Okay. An information memorandum is required to be filed. As I told you, you don't have to file a prospectus, but at least inform in a information memorandum. Prospectus requires approval. Information memorandum just needs to inform and leave. Okay, inform and issue. So information memorandum shall be prescribed in PAS 2. Now with that, it brings me to the form numbers. Okay, form numbers are PAS 1, 2, 3, 4, 5. Okay. PAS 2 is for information memorandum. This is issued for shelf prospectus. This is issued for shelf prospectus. Clear? The other form numbers are also there. Very, very important to know. Okay, which as and when we come, I will tell you. But you write it down. When we come to it, you need to fill it up. Okay. Now quickly moving ahead to the next type of prospectus. That's your red herring prospectus. Now red herring prospectus is a prospectus issued to the public which does not contain the complete details of the price of the securities or the number of securities issued. Then why do you issue the public red herring prospectus? It is issued to give a price band. Okay. Now pay attention. A red herring prospectus. Why it is called as red herring? Because the first company that brought this prospectus was the name red herring. Okay. Now let's understand the red herring prospectus. It is a prospectus which do not contain the complete details of the quantum of the price of the securities mentioned therein. So let me explain a small concept to you so you will understand red herring prospectus perfectly. Nowadays, there is red herring prospectus only issued by companies. So as a company secretary, it's very important for you to know it. Now see, whenever it comes to pricing of a security, pricing of securities. Now what price should I keep it as what price should I keep my securities? So there are two methods. One is a fixed price method. What do you mean by a fixed price method? Where the company fixes the price, for example 20 rupees. This was the traditional method, earlier method, where company used to fix. But how will you fix? What if the market demand is higher, or what if the market demand is lower? So we want to price the securities as per the market demand. So in such cases, you issue a red herring prospectus given under section number 32. Red herring prospectus is a prospectus which will not contain the price, but it will contain a price band. It will contain a price band, like we will ask the public, we will ask the people to bid between rupees 15 and rupees 30. On basis of the biddings received, we will come to know what is the market demand and people will bid. So I have also applied, and you will also very soon apply for any kind of IPOs that come in, which gives a price band. You can select. So sometimes when you really want it, you go in for the upper band and tell that even if it is a 30, I want the share. Okay. Most of the companies open up at, big companies open up the open band at the upper band only. So I can bid for it. Then the company will say that, okay, we have so many securities, we've got bids of 30 rupees. So now we will give it to all of them, and we'll then issue a final prospectus later and say that the price is rupees 30. So this red herring prospectus is issued simply to find the price on basis of the market demand. Now let's see, let me take you through a prospectus of Zomato Limited. Okay, now this is a red herring prospectus. This is a red herring prospectus of Zomato. So if you go to see, it is written that IPO of dash equity shares. They have not given the number of equity shares issued. Okay, at a price of dash. So here they have even given the price is also, it is not given. Okay, they will issue a price band within which the company needs to issue it. So this is the red herring prospectus of Zomato Limited. So as we saw, it does not contain the price, the offer price, but it is a simply bidding that needs to be done within a specific range. Okay, so now let's read from the module. It does not include the complete details of the quantum or the price of the securities therein. Okay, red herring contains most of the information pertaining to the company's operation. So it will be like a document which you try to pitch to the shareholders. Buy my share. These are the details. We try to create a demand. Okay, by giving people. So before even launching the real price, they try to market it by issuing a red herring prospectus. Give them all the highlights of your company, etc. Now there was an exam question with respect to this. Okay, with respect to red herring prospectus. Let's go to that and see what it is. Okay, so here this was just in the last attempt that they had asked with respect to the red herring prospectus. And you all need to tell me, and you'll also see what kind of questions that they ask in the exam. So this is the exam question. Okay, they've asked that Santosh, they might not directly ask you, but they will check your concept. So Santosh, CEO of a company, has advised the board of directors of an unlisted company in order to make a public issue and generate interest and awareness among the public. A prospectus can be issued without giving the details of the shares and the issue price. Examine the correctness of the advice. So we will start with facts of the case that the CEO of the company, Mr. Santosh, has advised the company to come out with this. Then you will say the provision under law. Then you will say your section number 32 talks about red herring prospectus. It's a prospectus which does not contain all the details. And then you will say conclusion that yes, Mr. Santosh is right. His advice is right, that the red herring prospectus contains only the basic details. It will help the shareholders know about the company and then bid properly. Clear till here? Now coming to section number 31 we did, 32 we did, now we are seeing section number 33 talking about abridged prospectus. Now what do you mean by the term abridged prospectus? For that we need to understand the meaning of the word abridged. Abridged means the highlights. Abridged means highlights or the salient features. Salient features. Now when you see the prospectus, let's see, look at the prospectus of Zomato. Okay, red herring prospectus. It runs into let me show you the number of pages that are there on Zomato's this. Okay, it's of 420 pages. It's of 420 pages. Okay, 420 page document. Okay, so can you see this? This is Zomato's red herring prospectus, which is of 420 pages. Now tell me one thing, would you be able, or a normal investor be able to read the full prospectus? Yes or no? You think that the prospectus they will be able to read? Answer is no. So in that case, what happens is the government is saying that please issue the highlights as a separate page, which could be small, could be 5-page document where you give the main highlights. That highlights is called as abridged prospectus. So abridged prospectus means a memorandum. Memorandum is a document, okay, containing such salient features such as a summary document, okay, as specified by SEBI. So shall issue such information. So no application form shall be issued unless it is accompanied by the summary document abridged prospectus. Moving ahead to next important concept called as offer for sale, okay, or deemed prospectus. So we saw prospectus section 2 subsection 70. Now we will see what do you mean by deemed prospectus and offer for sale. Okay, very important. Let's look at it. Okay, now this what we are reading is section number 25. Okay, now offer for sale. Can anyone tell me what in the chat box, what do you mean by the term offer for sale? What do you mean by the term offer for sale? Now offer for sale is very simple. Normally when high value shareholders, when you have some shareholders who have high stake in the company. Okay, first I'm giving you the general meaning of offer for sale, then you please understand what I'm trying to say. Okay, first you will understand this, then you will first you understand the concept, then you will understand the law behind it. Now there is a shareholder, let's say this is a shareholder, and he has 30% shares of the company. As today you want to buy any shares, you will swipe buy, right? Or you want to sell your shares, so you will swipe sell. Yes or no? Very simple concept. But if Mukesh Ambani wants to sell his shares, can he sell, and in his demat account can he put sell of such a huge holding? Answer is no. So normally promoters, key shareholders, when they want to exit, they say we can't just, that many buyers will not be there in the market. If Mukesh Ambani wants to sell around 10 lakh shares, that many shares should be there in the market, buyers should be standing. So what happens is, what do? They come out and announce that we want to offer our shares. So here there will be a shareholder, okay, he will go and announce to the public that listen, I have so many shares, anyone interested in buying, please come and buy. Okay, now this person in himself does not do it. What does he do? He engages some intermediary company or some issuing agent or some person who will do this procedure and then contact with the public and do something called like a issuing house, who will handle all the SEBI requirements. Because again, it's a public company making from a public company, a shareholder wants to sell his stake to the public. So then he will make an announcement, because huge shareholdings cannot just be sold off at the blink of an eye. Clear till here? Now coming, so this was one part. There is other part to it also which I will come. Till here it is clear. Offer for sale means what? Big guy coming saying that I'm selling my shares. Anyone interested, I'm offering it for selling. I hire my agent and my agent will do the work. Now what happens when my agent informs the public? So when this guy, this intermediary company is informing the public, so they will issue some document. All the rules of prospectus will apply to this particular document as well, where this intermediary company has to give full details, no misstatement, all the material facts should be given, and all the rules of prospectus will apply. Okay, now let's read section number 25. Now pay attention to what I'm reading. Okay, these people find it tough. Where a company allots to any allots or agrees to allot any securities of the company with a view to making those securities offered for sale to public. Any document by which, so let's break this down. Now this scenario, the second scenario which I'm talking about. Okay, second scenario. Now pay attention to what I'm saying. Now there is a company. This company, if it wants to issue shares, issue securities to public. Okay, to the public. Tell me one thing, do they have to follow the section 26 or no? For prospectus and matters to be stated in prospectus, yes or no? When a company is issuing shares to the public, that document is called as prospectus, and under section 26 they have to enter all the important matters in that prospectus. So company is thinking, let me do one thing, I want to escape this problem of disclosures. I don't want to disclose. So what I will do, pay attention. What the company is doing, company here is now trying to escape the prospectus regulations, because there you have to make disclosure. So company plans to give it to an individual, okay, and this individual then will make an offer for sale to public. Have you understood? So what happened when the company made a private placement, to this individual, it did not have to follow the rules of prospectus. Section 46 rules did not need to be applied or did not have to be disclosed. Yes or no? Section 26 doesn't apply when you're giving private placement. Then this guy who got these shares is now becoming a big shareholder and he is offering his shares to the public. So what law has said, that by this document by which he makes an offer to public, offer for sale to public, here the prospectus rules shall apply. Is the concept perfectly clear? Yes or no? So company makes it to an intermediary and that intermediary makes an offer for sale to public. So whichever document the intermediary is making to the public, that document will be called as a prospectus and all the rules of prospectus shall apply. Okay, now pay attention to what I'm reading. Okay, where a company allots any securities of the company, now just write here, to any person with a view to all or any of those securities being offered to sale to public. So I am giving it to you with the objective that you give it to the public. So company has indirectly made a public issue to the public, right? So then for all purposes it shall be deemed to be a prospectus issued by the company. In simple terms, any document by which the offer of sale of shares or debentures made to public is made, for all purposes it will be treated as a prospectus. The document offer for sale is an invitation to the general public to purchase to the shares of the person through an intermediary, whether it be any issuing house, etc. Okay, and all the rules will apply. And very, very important, what happens if the rules will apply? All the rules of prospectus will apply. Also the penalties, misstatements, all the criminal liability for misstatements, civil liability of misstatement will also apply. Next, according to the section, in order to constitute offer for sale, either of the following conditions should be fulfilled. Okay, now let's understand. When company gave to him, within 6 months only, he made a announcement to the public. So we will believe that the company intended to give it to this director with the hope that he gives it to the public. So within 6 months, intermediary given to public, and this guy has not even made the full consideration. Full payment of consideration also it has not been done full amount has not been given. So two things. This is the company has given to intermediary, and the intermediary within 6 months has issued it to the public, and the intermediary has not yet made the payments also to the company. So payment can be asked later on, 1 year time is given. So all this is there. So let's read. Either of the following conditions need to be fulfilled: that the offer to public was made within 6 months of the allotment, and at the time when the offer was made, the whole consideration is to be received by the company has not been received. So at the time of allotment to the public, at the time of so the whole consideration, that this guy intermediary has not yet paid the whole consideration also to the public. So these two conditions are fulfilled, then we will say that all the rules of prospectus shall apply to this offer for sale as well. Moving ahead, offer for sale by certain members. So market is important. Okay, important as in what I told you, big directors, big shareholders who have stake can offer the documents, offer their shares to the public. So let's read. Permits certain members of the company. It permits certain members of the company in consultation of the board of directors. So high value matters, in consultation with the board of directors, they can offer whole or part of their holdings to the public. So they can offer whole or part of their holdings to the public. The document by which the offer for sale is made to the public shall be deemed to be the prospectus issued by the company. So same first example which I had given you. A big guy talks to the directors and says, I want to exit the company. Such a big stake, I will go to the public and announce it there. Okay. Now all the rules of minimum subscription will not apply here because he is going to the public. Now coming to the section which I told you, section 52, 53, 54, 55. Now they will all come in a sequence. Okay. So be ready to write it down and note it down with me. So these sections. Okay. Now first one, section number 52. I want you all to put in the chat box, can the company issue shares at premium? So if the face value of the share is rupees 10, company makes a issue and the issue price is rupees 12. So what is the premium amount? What is the premium amount? Can anyone tell me? Very simple, it will be rupees 2. So a company may issue shares at premium. Okay. This is given under section 52 subsection 1. But whenever they issue the shares at premium, this premium amount has to go into a separate account called as security premium account. It has to go in a separate account called as security premium account. Very, very important. Okay, they ask in the exam also. There are 3 subsections. I wanted to know all of them. Section 52 subsection 1, 52 subsection 2 and 52 subsection 3. 52 subsection 1 says that whenever company issues shares at premium, that premium amount shall be transferred to security premium account. Okay. Second, subsection 52 subsection 2, which they ask in the exam. Okay, as well. Very, very important. Now I will ask you that exam question. Okay. That once it has gone into a separate account called a security premium account, can this company use it for buying of plant and machinery? This security premium account, for example, you have given me 12 rupees. 10 rupees I put in share capital account and 2 rupees I keep in security premium account. Can this, now security premium account has money. Can I withdraw these funds, utilize the security premium account for buying plant and machinery? Yes or no? Yes or no? Answer is no. Can they use it to pay dividend? Can they use this amount to pay dividend? Yes or no? I want you all to put in the chat box, can security premium account be used to pay dividend? Quickly. Very good. Answer is no. We have to first see that what does the law say. Says that you can use security premium account only for these purposes: 1, 2, 3, 4 and 5. For these 5 purposes only you can use. One is for issue of bonus shares. So now you tell me whether dividend you can use to pay. For bonus shares, for writing of preliminary expenses. For example, preliminary means pre-incorporation expenses. So before incorporation, I must have spent some amount. So that amount I can use security premium account to pay off that past expenses done at the time of before incorporation. Next is writing of commission paid or discount allowed on issue of shares or debentures. So if we have issued debentures or shares, we must have paid some commission, okay, all those things, underwriting commission, all those things, or I must have issued debentures at discount. So that all discount amount I can adjust it with my security premium account, the loss. Next is I can also use it to pay off my preference shareholders and to buy back shares. Is the concept perfectly clear? So I can use it for bonus shares, I can use it for preference shares, I can use it for discounts or commission to be paid, I can use it for preliminary expenses, and I can use for buyback. Concept perfectly clear. Dividend is nowhere written. So if in the exam they ask you, can it be done? So dividend, answer is no. Section 53 subsection 3, what does it talk about? That the security premium account may also be used for these purposes, okay, which they have given: buyback, for in paying up unissued equity shares to issued to the members as fully paid bonus shares. So for bonus shares, for buyback, and for writing off any of these expenses you can use. So all of them is given in a summary in 0.5 points. Okay, very important. In Henry versus Copper holding case, it is held that same point has been held, that where company issues shares at premium, even though the consideration may be other than cash, a sum equal to the premium must be transferred to security premium account. So very interesting point, that where a company issues shares at premium, even if the consideration is other than cash, still that amount has to go in security premium account. Means what? Let's understand. There is this person, he came to the company and he got plant and machinery. Or he got some intellectual property rights. Against this, the company wants to issue shares at premium. So now he has given consideration other than cash. So shares have been issued other than cash. So still whatever is the premium amount, that has to be transferred into security premium account. That has been held in Henry versus Ropner Holding Limited. Concept clear? Moving ahead to the next section. Which is the next section? Section number 53. Okay. Now 53 we've discussed is issue of shares at discount. Till I get this up, you tell me, can debentures be issued at discount? Read section 53 and please tell me, can debentures be issued at discount? Yes or no? Can debentures be issued at discount? Very good, very good. Yes. So debentures can be issued at discount. Shares, here what they've given, that section 53 says that a company shall not issue shares at discount. That means they can issue debentures at discount. Any share issued at a discount shall be void. There is one exception to it, where share can also be issued at discount, which is called as sweat equity of share. Very next section, sweat equity of shares. So can shares be issued at discount? two exceptions. One is sweat equity. What is the other exception? In what case I can issue it at discount? Can you all tell me in the chat box? What is the second scenario when we can issue it at discount? Quickly. Okay. So the other one is also very important to know. It is when a company is going under restructuring. Okay. And the creditor we have to repay, but we could not repay the loan. So in that case, we will tell the creditor, listen, I'm very sorry. I can't repay your loan. Let me give you shares. I'll give you shares at discount. So that is allowed. Let's read. A company may issue shares at discount to its creditors when the debt has been converted into shares pursuant to some resolution plan or restructuring plan according with the guidelines of government. Concept clear? So sometimes when the creditors could not be paid and the company says that I'll give you so much stake, you please take more stake in my company, and shares can be issued at discount. So two things. Shares of the company, issue of shares at discount is prohibited except by sweat equity. Sweat equity is allowed. Share premium is not available for distribution of dividends. So both of these things are important. Now coming to very, very important section number 39 of the company. What is section 39 of the company? Can anyone put? Very important section, that is your section 39 talks about allotment of securities. Clear till here? Allotment of securities. Allotment of securities. So what does it talk? That, and I want you to understand allotment, okay, because this has been an exam question also, and I will now take you through it from some logical point of view also. Now I will be writing something stupid, okay, just to explain you the concept. Allotment is like birth. Okay. So when the company issues the securities for the first time, when company issues securities for the first time, okay, it is called as allotment. Concept clear? Now why am I telling you this? Because there is a case law, okay, there is a case law, and you have to, it's an exam case law also. This is the name of the case law: Shri Gopal Chalan and Company versus Calcutta Stock Exchange. Very important exam case law, okay. Now what is this case law? And I want you all to make a guess. What happened is, company issued shares to member, okay. Member became bad debt and became a bad debt. He did not pay the money. So company forfeited the shares. They took the shares back from the shareholder, and then they reissued this share. They reissued shares to new person, new investor. Tell me one thing, can this be called as allotment? This went, it was issue of shares. Can this second scenario be considered as allotment of shares under section 39? Now why it is important? Because whenever there is a allotment under section 39, okay, allotment, company has to file PAS 3. PAS 3 has to be filed, which is called as a return of allotment, where the details of the allotment to whom you have issued for the first time will be there. So can reissue of shares be considered as allotment of securities? Yes or no? Quickly, I'm going to read your answers. So please put it up. Very good. So the answer under the case law is reissue of shares is not considered as allotment. It is instead considered as a transfer of shares. It is considered as a transfer of shares, because I told you shares allotment means birth. So when we gave it to him, when there was a birth, it has been given to him, but he abandoned it. So the same, so the share is already there and now it has a new parent. So the child is already there, okay, so the birth is already there. So therefore it is not considered as allotment and PAS 3 is not to be filed. So this is what they have given. The held at the exchange was not liable to file any return. So PAS 3 was not required to be filed when the share were forfeited and reissued, because it was observed that when a share is forfeited and reissued, there is no allotment. There is no allotment. Okay, very, very important. Now, basic rules of allotment. Basic rules of allotment is given here. First, in order, whenever we allot the securities, the minimum subscription should be done. Minimum subscription is 90% of the public should subscribe. If 90%, for example, I make an issue of 100 shares to the public, minimum 90 shares should be subscribed. If 90 shares are not subscribed, then it will be treated, okay, if 90 shares are not treated, it will be treated as an undersubscribed issue and the money has to be refunded. So very important is, allotment shall be made only when the minimum subscription in the prospectus has been received, and minimum prospectus given is 90% of the issue size unless otherwise stated. Okay, so minimum amount is given, has been taken, so minimum subscription should be received. The minimum application amount should be given. Second, PAS 3 is a return of allotment is to be filed. I told you PAS 3. Till now in the chapter we have done PAS 2 for shell prospectus information memorandum, and we have done PAS 3 which is return of allotment. Clear till here? Next, along with PAS 3, a certified list of allottees has to be given, that how many list of allottees are there, etc. In case of securities not being bonus shares, okay, let's say again if I give you, if there was a case where securities have been issued allotted for consideration other than cash, means someone has got some building, car, he has got some asset, intellectual property. So against that, when we are allotting, the details of that should be given. If the contract of that is there, that a contract has been made that you get building and we will give you shares, so that has to be given in PAS 3. If that is not there, a contract was not entered, then a separately you will have to mention that these are the details and give it in PAS 3. So again, in case the securities are allotted for consideration other than cash, so you are not getting cash, you are getting some other intellectual property, etc. A copy of the contract. So if we have a contract already that I will get IPR, and against that, so that also duly stamped has to be attached with PAS 3. A valuation report, that if you are getting assets, what is the value of the asset, which asset are you getting, against what asset has been given, that also has to be done. And another important point, I want you all to put the number here. Mostly people get the numbers wrong. If the share price, okay, the face value of the share, is rupees 10. What is the minimum amount that the company can ask on application money? See here, I'll read it like I want to do some maths calculation. The amount payable on application on every security shall not be less than 5% of the nominal value. So minimum application amount, okay, shall not be less than 5%. So how much does it come up to? Please put in the chat box. So minimum company has to call in the first minimum application money, then comes first call, then comes second call. So all of that. Very, very good. So those who are saying 5 rupees are actually, this is, if 5 rupees would be 50%. And here we want only 5%, not 50%. So it would be how much? 0.5 rupees. Okay. So read the question properly. If the minimum amount or minimum subscription is not received, everything will be refunded. Then we did this case law, very, very important. Note the name of the case law and write it down. Okay. Then comes next. Next is estate versus Hiralal. Inadequacy of consideration and the shall be liable to pay them in full. So again, what it was said that in this case law, it was held that inadequacy of consideration, the share shall be treated as not fully paid and the shareholder is liable to pay. We've heard of forfeiture, surrenders. So if at all the shareholder could not repay the amount, then he will still be liable to pay the entire amount of the share. If he doesn't pay it, then it can be forfeited. This is not important. Coming to the D part, official liquidators, allotment of shares against a promissory note shall not be valid. For example, if I say I promise to do something, so like that shares are not allotted. We know how shares nowadays, you subscribe in an IPO and you get it. Now general principles of allotment market is important. Basic principles that allotment should be done by the board of directors. Allotment should be done within a reasonable time. It should be absolute and unconditional. I cannot tell that sing a song then I will give you. If you have subscribed, you've given the money, I have to allot it. It should not have then ifs and buts. It should be communicated and it must be against application money only. Now very important is allotment meaning. What do you mean by allotment? So it will sound very tough. Allotment means to give the securities. So company had permission to give 10 securities or that authorized capital they had X amount and earlier they have not yet given. So from the left out portion they are going to give the shares. So allotment means appropriation from the unappropriated capital. So it's an act of giving the shares. Allotment means giving first time. So if the company had a right to issue 100 shares and they have just issued 90 shares and they have to issue 10 more. So from the 100, 10 which they have not yet given, they are giving again. So it's an act of appropriation out of the previously unappropriated capital. So till now, because allotment is fresh issue only, so earlier they must have not issued. Allotment in contravention should not be in contravention against any law. Now these are all general case laws that in Royal British Bank that allotment shall be valid even if there is some defects in the appointment of the director. So for example, the proper agreement was not done, but still allotment will be valid. Allotment by the board irregularly constituted may subsequently be ratified by a regular board. So if the board of directors, some of the board of directors have allotted the securities and it was not done properly, later the board of directors can regularize or make good the defects. A director who has joined in an allotment to himself will be stopped from alleging the invalidity of the agreement as given here. Now what does it mean? A director who has joined in allotment to himself. A director has allotted shares to himself. Now he cannot deny the liability and the responsibility of it. So what happens if a director has allotted shares to himself, then he is stopped. He is stopped from denying the validity of the allotment and he has to pay the amount and he will be liable for as a shareholder. There are no proper allotment of a share unless the applicant has been informed for the allotment. Now coming to share certificate, and very, very important, few case laws can come up from here also. Okay. Now next is what do you mean by the term share certificate? So share certificate is a physical document, okay, issued by the company to the shareholder mentioning how many shares is he entitled to. It is issued under section 45 and it says that a share certificate shall have a distinctive number. Share certificates are issued under SH1 and share certificates are normally issued under the company's common seal. Okay, common seal is attached. But tell me one thing, this is a past exam question also. Is a common seal mandatory? Is a common seal mandatory? Yes or no? Is a common seal mandatory? So here in section 22 subsection 2, okay, it is stated that you do not need a common seal. Instead, a share certificate issued under the common seal, if any. So company may not have a common seal of the company. It can be signed by two directors or by a director and a company secretary. So very, very important that the company can have a common seal, then it's fine. But if they don't have a common seal, then two directors and a company secretary sign has to be done. And the company has appointed a company secretary is a prima facie evidence of title to the share. So if it has been signed by the company secretary, it will be believed and that you are entitled to the number of shares. Now moving ahead quickly. Who can, when can a company issue duplicate share certificates? So when they have lost or destroyed, defaced, mutilated, torn or surrendered to the company. For example, if you've lost the share certificate, then you can ask the company to give it to you. Now, in which of the two cases will a board resolution be necessary? I want you all to tell whether case A or case B. Now you've lost or destroyed it and you're asking for duplicate share certificates. So original share certificates are in SH1, duplicate share certificates are in SH2. So when it is lost or destroyed or torn or defaced or mutilated, when is board resolution required? Quickly. Case B, answer is no. In this case, board resolution is mandatory. Mandatory. Why? Can anyone tell me why? Understand. I have come to you as a company secretary and saying that I have lost my share certificate. I don't have any proof. Please issue me duplicate share certificate. So you will say this guy doesn't have anything. He's saying it is lost or it is destroyed only. How do we issue? Let me ask the board of directors. So board of directors is mandatory. But in the second case where it is defaced, means it is torn, you have bought a document, you've surrendered the document to the share, but it is torn, it is in two pieces, it is not proper, so there is not much risk. So therefore board resolution is not necessary in the second case. Concept clear? Now from here, issue of share certificates, very, very simple. This is in rule 5 for issue of share certificates, and issue of duplicate share certificates are in rule 6. Here, if you go to see, a company shall not issue duplicate share certificates, okay, in lieu of destroyed or lost without prior consent of the board. So this is what I had asked. Board of directors shall not issue any duplicate or share certificates in lieu of the lost or destroyed without the consent of the board of directors. Here again, to issue the securities, it is only the board of directors who have passed a board resolution are the proper authority to issue share certificates. Share certificates are issued in SH1, okay, and it can be certified or signed by under the common seal or two directors, and one should be a company secretary. Okay, if the company secretary has signed the document, it will be deemed that if the directors have a facsimile signature or an electronic signature. Nowadays, if 1 lakh share certificates are issued, The directors will not keep on signing it. They have these signatures which you must have seen on your college iCard, the signature of your principal. That's a fast smile signature is also allowed, and you have to maintain a register. For duplicate share certificates, it can be done only if you surrender the old certificates. A charge will be taken but not exceeding 50 per certificate. In case of lost and destroyed, you have to get a board resolution. And duplicate share certificates are maintained in SH2. Okay, the register shall be kept at the registered office of the company, and shall be preserved permanently by the company. Now coming to the next parts, not very important. Okay, maintenance. So share certificates will be issued only after the resolution of the board of directors. Who's responsible for maintaining and preserving all the books? Obviously, you will see the company secretary. Okay, the committee of the board and the company secretary are responsible for maintaining all the share certificates. Next, records of depository prima facie evidence in depository form. Very, very important. Nowadays, physical share certificates are not there. You must not be having physical shares if you're trading today. You're dealing in online shares, demat shares. So if your name is mentioned with the depository that you're holding shares in demat form, it is prima facie evidence. It is on the first look, we will believe that you are a shareholder if your name is mentioned with the depositories of India. Can you all tell me which are the depositories of India? One is your NSDL and CDSL. Now, time limit to issue the certificates. Okay, very, very simple. Remember this: 2 months, 2 months, 1 month, 6 months. So if you have subscribed, okay, in how much time should we issue the share certificates to you? So issue of share certificates, very, very important. You have to remember with the subsection number, section 56 subsection 4. What does it say? If it is given to the subscribers within 2 months, or if it is allotted to you within 2 months, the share certificate should be issued. If it is a case of transfer or transmission, then 1 month. And if it is a case of debentures, then within 6 months, the debenture certificate should be issued. Signature of share certificate. Significance of a share certificate is very, very important. It is evidence, prima facie evidence that you are the legal owner. It will be evidence that you are the member of the company. Okay, and very important, this was a case law, Society General de Pales, that is prima facie evidence. Second, if you are a shareholder and the company has done something fraudulent, you can compel the company for compensation. Okay, just because you have a share certificate, you will get all the rights and you can file cases on the directors, etc. Okay, as a shareholder. And no company cannot dispute the amount on the share certificate already paid. So if it is written that it is fully paid, then the company later cannot deny that you have not paid the amount. And you can even claim damages against the company or directors who have issued wrong certificate. Next, coming to split certificate. Okay, here, what do you mean by the term split certificate? Any idea? Split certificate. Very good. So split certificate is, let me explain. For that you need to know a concept. Let's say I have subscribed to 300 shares. I have subscribed to 300 shares at one go. The company might issue me not 300 share certificates. They will issue me one share certificate which will mention that I have from the number 1 till number 300 I have the shares, right? So I will have one share certificate showing that I have 300 shares. I am entitled to 300 shares. This is something called as a stock certificate. This is something like a stock certificate. Clear? Now, in this stock certificate, what if I want to sell off 100 shares? If I want to sell off only 100 shares, so do you think they are going to tear this up? Answer is no. You have to surrender this and a split certificate will be issued by the company. One is of 100 shares and the other one will be in my name of 200 shares. So this is the concept of split certificate. So okay, so a split certificate is a separate certificate claimed by the shareholder for the portion of his holding. So I'll say 100 shares, give it to that, I'm transferring it. The 200 shares, give it back to me. Purpose and form of a share certificate, it's a prima facie proof, evidence that you have a marketable title. Whether a share certificate is an official document, very, very important past exam question. I just want a yes or a no. Is a share certificate an official document of the company? Yes or no? I'm waiting in the chat box. It's a past exam question. Is a share certificate an official publication of the official publication? Yes or no? So they say that a share certificate is a prima facie ownership rights. It gives rights towards your title, but it is not a official document like your prospectus. This was held in circular number and all the details as well. Okay, prima facie document of title. It says that the shares are movable property, transferable. Okay, and that the share certificates are movable, but they are not publications in the nature of prospectus, balance sheet, profit and loss account or advertisement. Clear? Now, legal effect of share certificate. What do you mean by the legal effect of share certificate? It means you are estopped from title or payment. That means no person can deny, the company cannot deny title, that is your ownership rights, and the company cannot deny the payment rights also. That means if it is written that Mr. X is the owner, the company cannot deny that Mr. X is not the owner. If it is written that the company, that the shareholder has paid up 100 rupees, he's paid up 100 rupees, so the company cannot deny that 100 rupees has not been paid. So the company will be estopped from denying ownership rights to the shareholder, or they will also be estopped from denying that he has made the payment rights to the shareholder. Now, personation of shareholder. So if any person impersonates, tries to become a shareholder and tries to get some dividend rights, for him we have imprisonment and fine as well. Okay. Now we come to the next part, which is issue of securities. So this is one of the most important parts of your chapter. First is equity shares with differential voting rights. Now when I discussed earlier, I had told you all very important section to remember, that is of your differential voting rights. This is your past exam question as well. What is the section number? Section 43, read with rule 4. Read with rule 4. Okay. It talks about differential voting rights. Now, if a company wants, they can issue shares with deferred rights, with rights with respect to voting, with respect to payment of dividend, etc. So DVRs can be issued subject to certain conditions given under Rule 4. Now Rule 4 talks about first which type of resolution is required. Then they say that the company should not be in any default, and the maximum DVRs that can be issued. Is this clear? So these 3 points are important in Rule 4. So let's see. First, can you all tell me which kind of resolution is required to issue these DVRs? Okay, so section 43 read with rule 4 states that regarding the shares with differential voting rights. So first, only a company limited by shares can issue equity shares with differential voting rights with respect to. Now remember, I told you all in the start, DVRs, though it is said as differential voting rights, but differential rights could be with respect to dividend, with respect to voting, or otherwise also. Clear? At the time of repayment, first pay me, then pay to other equity shareholders. Now from this line, they have asked the exam question, and I will take you all through the exam question, and I want you all to tell whether what is your answer on it. Okay, so we're seeing the next question. Okay, so this is the exam question that was there, and it is of June 2022. Okay, June 2022 question. What is the question? Which of the following companies is eligible to issue DVRs during the financial year? Firstly, Company A, limited unlisted company, has default in filing in year 2018-19 and 19-20, and default was made good during the year 2020-2021. Okay, whether the articles of the association are authorized to issue the DVRs. So what is your answer? Yes. And in company B, no. Okay, so whether the companies can issue DVRs, this company which has made a default, and second is a private company. So let's read the provision and then we'll try to answer it together. Okay. Now, first, articles of association should permit. So we are seeing the conditions for issue of DVR. So every time it comes in the exam. First is they require ordinary resolution. I think someone had said special resolution. Answer is it is not special resolution. It has been amended, and now to issue DVRs you require only ordinary resolution. Next, if you go to see, okay, what is the maximum amount of DVRs that can be issued? That is, it shall not exceed 74% of the total voting power. So maximum is how much? 74%. Now everyone in the company cannot have special voting rights. So the maximum that you can issue is 74%. Okay. So 74%. Then they only talk about default. Company should not have defaulted in this, that, etc. Company has not defaulted in filing financial statement for 3 financial year. Then the company has no subsisting default. So existing default should not be there for declaration of dividend, etc. Company is not defaulted in payment of dividend, preference shares, any kind of deposit rights. Okay, company may issue equity shares with differential upon the 5 years from the time it was made good. And the company has not been penalized by the court. So if you go to see this, they talk about should not be penalized and all those points. Ordinary resolution is required, maximum 74%. Now after reading this, let's see this. What it is written that only company limited by shares, okay, only a company limited by shares can issue this. So a private company, okay, here. So section 43 read with rule 4 states that a company can issue DVRs if the articles authorize and can be issued by company limited by shares only. Company cannot issue shares if it has defaulted in the financial statements for 3 financial years, in which is to be decided by the shares. This is given in section 43. In light of the above provisions, a company in light of the above provisions, okay, limited can issue DVRs. Company would be ineligible to issue if it has defaulted in filing for annual returns for 3 immediately preceding financial year. So here it has defaulted only for 2. So if it is defaulted for 3 immediately financial years, then it will not be there. A company has defaulted for only these 2 years and they have then made the good, so they can issue. B Private Limited cannot issue DVRs unless it alters its articles in such a way to authorize the DVRs. So private companies, they have to alter their articles to remove and then they can issue. Next, disclosures in the explanatory statement. So obviously you're issuing some DVR, so you need to make a lot of disclosures to whom you're giving, why you're giving, how much amount is given, justification and all those details. Okay. Then when you see procedure for issue of DVRs, now any procedure comes, I will give you a certain technique. If any procedure comes, you will be able to build it up. Now, whenever they ask you a procedure, understand everything starts with authorization from articles. Articles should authorize. Second, there would be a board resolution. So company must call a board resolution. Before board resolution, you will have to send a notice. You will have to inform stock exchange. Then you will have to convene the board meeting and then you will have to pass a board resolution. Once you do that, then you will move forward and you will send a notice for general meeting. Same points. You will send a notice for general meeting. You will inform stock exchange. You will convene the meeting and then you will pass a ordinary resolution. Till here it is clear. Once this is done, then you have to remember, you have to inform the stock exchange before and after if it is a listed company. Before the meeting and after the meeting, this is as per reg. So stock exchange has to be informed before the meeting and even after the meeting. This is as per regulation 29 of LODR and this is as per regulation number 30 of LODR. Clear? So check with the articles, hold a board meeting and then you write all the section specific provisions. Section specific provision means what you will write. Now remember what is given in section 43. You will mention that it should not have defaulted. You will mention that the article should mention 74% and all those details will be there. And I told you in this chapter, whenever any form you have to do, any kind of issue is there, PAS 3 has to be filed. Clear till here? Then comes issue and redemption of preference shares. Section 55, as I saw in the sequence, remember, talks about issue of preference shares. So company cannot issue irredeemable preference shares. It can be issued for 20 years, but infrastructure companies can issue it for 30 years with a condition that every 10% should be redeemed after the 20th year. Means moment the 20th year is over, for infrastructure companies and projects, 10% should start to be redeemed. So by the end of 30 years, the entire amount will be redeemed. Then comes some of the conditions. It should be redeemed out of the profit. It should be redeemed only if they are fully paid. A sum equivalent, whenever you are redeeming, a sum amount has to go to capital redemption reserve. Okay. So these are the points. Then when you come to the next important part, procedure. Whenever procedure comes, you should know the same concepts will go. And if it is a special resolution, so whenever we are issuing any kind of security, bonus, share, special resolution needs to be taken. And if special resolution is there, you will have to file MGT 14. You have to file mandatorily MGT 14. And whenever issuing securities, PAS 3 also has to be filed along with all the details. Okay. Now SH 7, what does it come for? Now this is also very interesting, where you can fit it anywhere. If the company has hit the maximum amount they can issue, or the authorized capital is 1 CR, they've already issued 1 CR, then they have to alter the alteration of share capital. They have to increase the share capital. SH 7 will have to be filed. So if the company is altering their share capital, then SH 7 will be filed. Okay. Now, in case if the preference shareholders have any kind of issue, then as per section 245, which gives them a class action rights, where all the preference shareholders can come together, okay, where they fill up the requisite majority given, then they can file for operation and mismanagement. Now coming to the next important concept, which is of further issue of capital, which is a past exam question also, section 62. So let's come to it. Section 62. Okay, let's see if you know it or no. Okay, till here everything is clear, yes or no? It's for so MGT 14 is for all special resolutions. Till here it is clear, yes or no? Can we move ahead? So we start with section number 62. Now 62 1A B C. Yeah, MGT 14 is only for special resolutions. Now 62 1 A, B and C. A talks about right issue. Right issue. B talks about ESOPs. And C talks about private placement or preferential allotment. Clear till here? Clear till here? Yeah, perfect. So this is about issuing to holders of equity share capital, that is your right issue. Employees, so this is about ESOPs. And any person, this is about preferential allotment or private placement. Let's understand each one and clear it up. Okay. Now, first is, let's understand the concept of right issue. 62 1A. Okay. Now, when a company wants to issue fresh shares, more shares, raise further capital, if the company wants to issue more shares and raise further capital, tell me one thing, don't you think they will first offer it to the existing shareholders? Tell the existing shareholders that, see, you already trusted our company. Do you want more shares? We will give you at a good price. So when the company issues the shares to the existing shareholders, it is called as right issue. When it is issued to the existing shareholders, it is called as right issue. Clear? Now what are the conditions for right issue? First, the company will, how do you think they will inform the shareholder that they want to issue further shares to them? So they will issue a letter of offer. A letter of offer will be given to the shareholders. This letter of offer will be open for 15 to 30 days. So they will give them minimum this much time, minimum 15 days, minimum 30 days. People want, they can subscribe. Now, when they subscribe, some will subscribe, some will give up the shares. They will renunciate. So if they want, they can subscribe or transfer, and whichever shares has not been taken up, the board of directors will dispose of the extra shares. Dispose of shares which have not been taken up. Clear till here? Now let's see. Now let's read from the module. Okay. Now the letter of offer which was there, the offer letter shall specify the number of shares. It shall be open for not less than 15 days, not more than 30 days. It shall be deemed with a right to renunciate. So if a person wants to give up his shares, he can renunciate. It can be rejected. Then the board of directors will dispose of all these shares which has not been taken up. Now, period of notice of offer. As per rule 12A, the time period within which the offer shall be made to the shareholders for acceptance shall not be less than 7 days from the date of offer. So it has been inserted by the 2021 amendment. It states, okay, that as per rule 21A, the time period within which the offer shall be made to the shareholders for acceptance, okay, that we give to the shareholders shall not be less than 7 days from the date of offer. So for example, if I give an offer to you and I say that you can accept this offer, so it shall not be less than 7 days. Okay. The notice of this offer shall be dispatched through registered post or by speed post or by electronic post or by courier or by any other mode, as long as if I have a proof of delivery to all the shareholders at least 3 days before the opening of the issue. So whenever I'm opening the offer, at least 3 days before, I have to ensure that everyone has got the notice. So what will happen? First the notice will be given, then I will tell them that if you want to subscribe and approve of it, the issue opening date is so and so. The period will start from this date, it will end from this date. Now let's understand this point. There was a past exam question, okay, with, let's see. So this was the past exam question. The articles of association, I want you all to answer this. The articles of association provide that the documents may be served upon the company only through a registered post. So the article says that the document should be served upon the company only through registered post. Now Ram, what did he do? He dispatched it by courier. The company did not accept it, saying that it is a violation of the articles. Examine the provisions of the Companies Act whether the refusal to accept the document by the company is valid. So what company in the articles they had said that whenever you send me any letter, it only has to be through registered post. Courier and all the other things are not valid. Shareholder give through other modes. Is it okay? Yes or no? Will the shareholder succeed or the company will succeed? Can the company refuse the acceptance of this document because it has not been according to the articles? So the answer is company will not be allowed to say that. Why? Because by law, okay, in section 20 only of the Companies Act, it is stated that the document may be served to the company or on the officer through any of the modes, whether it be speed post, registered post, courier or delivering, by anything, as long as you have proof of address, it is fine. So when the company is putting in the article that only through registered post you can send us letters, then you are going against the Companies Act, and the articles of association cannot exceed the Companies Act. Now this was a past exam question. Now moving ahead to the next thing. Procedure for write shares. Now whenever I told you any procedure comes, you will write it should be authorized, articles of association should be there, then you hold a board meeting, then you take a special resolution. If special resolution is there, you will file MGT 14. PAS 3 is a standard form and SH 7 is for alteration of share capital in case you want to issue more than the authorized share capital. Now coming to employee stock option scheme. Now what is ESOPs? Many don't understand the concept of ESOPs. Let me explain. If an employee is there, if a employee of the company is there, okay, he is very hardworking, we can have a compensation committee. Now what does the compensation committee do? They figure out all these employees who are hardworking and to whom we want to retain. Because nowadays the biggest talent is not only finding talented people but also retaining them. So the compensation committee will identify these talented employees, and then we will give them options, employee stock options, where we will give them shares or securities, but it will be subject to lock-in. They will be subject to lock-in and they have to work with the company. Minimum lock-in period that a company will put is 1 year. Beyond that, the company can say, see, listen, we are granting you some ESOPs. You be with the company for 5 years, and after that all this ESOPs will become shares and you can then sell it off in the market. But if in the lock-in period you leave the company, you will lose all your rights. For this also company has to take special resolution. There will be a compensation committee which will identify employees. They will make the scheme. What if he dies, death, or he retires, or he is removed, what will happen, or he is disabled, what happens with his rights. Okay, so this is about employee stock option schemes. Option may be given to any director, officer, or employee of the company. Whether you want to give the holding subsidiary, you can give that. Okay. Now rule 12 of the company share capital and debenture rules. A company which is not required to comply with SEBI shall not offer to its employees under the scheme unless it complies with the following requirements. So they have to comply with all these requirements. Now again, very important point, highlight this, that a special resolution is needed, but if it is a private company, ordinary resolution will be fine. Private company will have to take ordinary resolution for making issuing ESOPs, whereas all other companies, that is public companies, will have to make a special resolution. Now who is an employee? A permanent employee. A director can also be given, but a director should not be holding more than 10% stake. Okay, so here they will give you that director should not be holding more than 10% stake. Promoter, it cannot be issued. You can give it to an employee also, but shall not include an employee who is in the promoter group, who is a promoter of the company, and a director who is holding 10% or more. So can ESOPs be issued to a person holding 5%, employee who is holding 5% shares? Answer is yes. Can ESOPs be issued to a director who is holding 20% shares? Answer is no. Can it be issued to directors? Promoters? Absolutely not, irrespective of holding. So this is also important. Who are employees? Okay, then all this is not important. I'm taking you through things which are important from exam point of view. They have to comply with the accounting standards. If there is any variation, again they will require special resolution, and the variations can be done as long as it is in the benefit of the employees. Minimum lock-in period is 1 year, that is called as vesting period or waiting period. So the employee has to wait for that much time. Freedom to specify the lock-in period. So the company wants, they can keep the lock-in during that much time. The employee cannot leave the company. If he leaves, he will lose the ESOP rights. So company has a freedom to lock the securities, but these lock-in will be for more than 1 year. No dividend rights or voting rights till the exercise of the option. So till the entire share, the ESOPs are vested with you, are granted to you till you complete your lock-in period. Till then, whatever dividend is there, you cannot claim, you cannot vote in the company also. So once the rights have been given, then all the share along with all its benefits will be given to the shareholder. Forfeiture or refund. Okay, the amount, if any, payable by the employees at the grant of the option may be forfeited if the option is not exercised. So normally if the share we work is of 50 rupees, okay, that we have shared the price the share as 50, we can take some amount from the shareholder, from the employee, that 30 rupees you pay. Okay, after 5 years, if you completed it, then we will grant it to you. But if he leaves in between, then this amount will be forfeited. So shares are not given free of cost. We will give them at a discount. But also we will keep a condition that if in between you leave it, whatever you have paid will be forfeited. Okay. So if the market price is 70, we will still give him at 50, and we will tell out of 50 you pay 30 now, 20 you pay when you completed your tenure. So at 50 rupees you will get. But if he has paid 30 and he has left the company, then he will lose all his rights. Okay. Now another important condition is the option granted shall not be transferable to any other person. So if we have given it to employee A cannot say that all my rights give it to employee B, because the compensation committee must have identified him, found that he is the talented employee who should be retained in the company. Option granted shall not be pledged, hypothecated, mortgaged by the employee. Very, very simple. He cannot pledge, he cannot keep it as a security and take a loan, because shares has yet not come in his name. He has to complete the lock-in. Okay, no person other than the employee shall be entitled to exercise the option. So only the employee can only come and claim it. If there is a death, permanent disability or resignation, then what will happen? So if there is a death, it will go to his legal heirs. If there is a permanent disability, from the date of permanent disability, it will go in the employee's name. If he resigns, it will be forfeited. Next is disclosure in the board report. So what is the disclosure in the board report? So all the details of the ESOPs will be given to the shareholders in and attached in the board report. Company has to maintain a register of ESOPs in Asset 6. So maintain a register in Asset 6. So register for ESOPs. Make a note. Listed company will have to follow new regulations, that is your SEB regulations, which have come in 2021. Procedure, again very simple. I told you, board meeting, articles authorized, general meeting, special resolutions, or MGT 14. Now if it is going beyond the share capital, Asset 7 and PES 3 need to be filed, and Asset 6 also maintaining a register. PES 3 also has to be filed. And if you remember section 56 subsection 4, it had stated that time limit, so has within 2 months of the allotment it should be issued. The third we are talking about is preferential allotment. Now another very important part, okay, new very important part. Let's see. Okay, now issue of shares on preferential basis. First, let's see, we'll take a short break at moment bonus shares. Okay, so what we'll do is we'll just take in a break now, okay, and then we will start. So we will return back in 9:45 p.m. Clear? So we take a short break and then we return. I hope till here it is clear. Do share with your friends, and also inform your friends that tomorrow also there will be a session, 2 days, that will be covering takeover code in complete detail. We'll take in a small break, water break, and we come back in sometime and complete the remaining part of the chapter. Okay? And don't forget to like the video. Okay, so I'll see you all soon. Hi guys, am I audible to you all? Yeah, just in the chat box you all can put if I'm audible to you all. I'll quickly start and we'll quickly wrap up with the chapter with the most important parts I'll give you all, which comes in the exams. So I just need a confirmation from you all if I'm audible. Okay, Karthi, great. Great. So we'll begin and great. Wali, great. Nice. Mariam, nice. Okay, so what we will be doing is I will take you through in a quick rapid revision of this chapter. Okay, and I will give the most important parts. Okay, so I will focus only on the important thing which comes in your exams. Okay, so let's begin and start with this. And after I am done with this chapter, it's your duty now to study this chapter and finish it off in one go. Okay, so let's start. Issue of shares at preferential basis. Preferential basis means issuing it to a selected group of persons where the company already in advance knows to whom they are allotting. So issue of shares on preferential basis means issuing it to persons, to certain selected persons. Company knows in advance to whom they are going to issue. They require a special resolution for this particular issue, and they require a valuation report as well. Now they're explaining the meaning of preferential offer. So the section of preferential offer as we did is section 62(1)(c) and read with rule number 13. It says preferential offer means an offer given to a selected group of persons. It's not a public issue. Public issue, we don't make it to specific persons, we make it to public at large. So here they have given you the conditions. Preferential issue by this. So first, again, very simple, article should authorize, special resolution is needed. You need to inform all the shareholders of all these details. Then comes the moment the allotment is done. The allotment should be completed within 12 months of passing the special resolution. So this is important. If it is not completed within 12 months from the date of passing the special resolution, then another special resolution needs to be done to complete the offer. For example, if I have decided that I want to allot it to you, we passed a special resolution today, within 1 year, the allotment should be done. Next, the price of the securities at which we are giving should be found out by a registered valuer in a valuation report. Why? Because we are giving to selected person. Now it shouldn't happen that we give them at a very big discount or at some varied price, because this is not given to public and it's not a uniform offer. To selected persons I'm issuing. Now if convertible securities are issued, then their convertible tenure should be maximum 18 months. Here they have given you where the convertible persons are offered and get equity shares allotted. The price pursuant to which shall be determined by either upfront at the time of the offer on the basis of the valuation report. So when we are giving convertible securities, for example, we are doing CCDs, convertible debentures, okay, convertible debentures. So when we issue CCD or OCD, optionally convertible debentures, compulsorily convertible debentures, so these are convertible issuance. So the conversion price, that one debenture will be turned into how many equity shares, can either be decided upfront or at the time which shall be within 30 days to the date when the holder of the convertible security becomes entitled to convert them. Then comes where the shares and other securities are to be allotted for consideration other than cash. So for example, again we had decided if he's getting some instead of money he's getting some property, some kind of intellectual property. So a valuer should value it, okay. And if it is the non-cash consideration, then it will be decided that what kind of asset is he getting. Okay, is he getting assets which will be put into the balance sheet, or it will be put into the profit and loss account. Okay, so for example, the company is issuing shares to an individual. Okay, selected group of person, they're issuing 100 shares. Against that, he's going to get some asset. So this asset is going to be put in the balance sheet. So if it is forming a part of the balance sheet, then you have to ensure that the accounting standards are followed. Okay, but if you're getting something which is not going to form a part of the balance sheet and it's going to be expensed it into profit and loss account. For example, the person is getting some kind of he's giving some kind of rights. Now those rights are not going to form a part in the balance sheet item. It could be some some things which are not that valuable that should be put in the asset side. So when we buy a small pen, or we buy some smaller assets, now all assets don't go into the balance sheet. Some of them are expense. So both of them, they're saying that it shall be treated in such a manner that if it takes in the form of a depreciable or amortized asset, then it should be put into the balance sheet if it is a proper asset. Otherwise it should be expensed out. Next is provisions of this PAS 4 and PAS 5 will apply. So first we are done PAS 1, 2, 3, 4, 5. This was what? Return of allotment. Return of allotment. This is a private placement. For private placement, letter of offer. Letter of offer. Here it is maintaining a register of private placements. Okay, in PAS 5. 2 we had done was shelf prospectus. Shelf prospectus information memorandum. And 1 they are not given here. It is when you're varying the objects. Varying the object clause. Then you need to file PAS 1, that you're going to alter the, you've raised money for purpose A, but now you're varying the object, and PAS 1 will be filed. Procedure for allotment, again very simple, since a special resolution, same forms. Now private placement is given under section 42. It will have very similar points, very few minor variations are there, where this can be issued in cash, here you can't take cash, etc. So let's read. Same points will come in. Private placement means making an offer to a selected group of person other than by way of public offer. Preferential issue can be made by public companies also. As a private placement is generally when it is privately placed to a selected group of persons. Now, this is very important. How many persons we can issue it to? So the answer is it should not exceed 50. Max 50 at a time and 200 in a year. So when we are making a private placement, we can make maximum to 50%. Okay. Now the private placement shall be made only to a selected group of persons who have been identified already by the company, whose members shall not exceed 50 or such amount as may be prescribed. So it can be increased up to 200 also. Now while computing 50 or 200, two kinds of people should be excluded. One is employees and other one is QIBs. So QIB should be excluded and employees should be excluded. Okay. Applying to private placements. So again, if someone is applying the shares in private placement, first is a letter will be given. We have to identify the person to whom the private placement will be given. Okay, and he can give the subscription money either by way of check, demand draft, or other than banking channel, or not by cash. Next is time limit for allotment. Now very simple. First is moment we pass the resolution, allot the securities within 60 days from receipt of application money. So moment we got the application money, within 60 days we will allot. If we haven't allotted in the next 15 days, we will have to refund along with 12% interest rate. Now this was a practical life question also. What happened is the company received the subscription amount. They received the subscription amount of private placement. And now suddenly they wanted to spend the money for some urgent purpose. Can that company use this subscription money for payment of salary or payment to suppliers? Can the company do that? Subscription money quickly. Okay. Can the company use the subscription amount which is received in private placement for payment to supplier? Answer is no. Company had, that was a practical life scenario where this was there to 42 subsection 6. Money received on application shall be kept in a separate bank account and can be used, shall not be utilized for any purpose other than adjustments against allotment. For example, you made an application money. If I'm allotting you, then I can adjust it against allotment and say balance amount, this much you have to pay. Or I'm saying sorry, you did not get it, I have to refund the money for unable to allot. For no other purpose, application money can be used. Offer to be made specifically addressing to a person. So a letter of offer, if you've ever seen, it will be addressed to Mr. Smith or Mr. XYZ to him. Return of allotment, PAS 3. Any kind of issue of security is there. PAS 3 has to be filed, which is a return of allotment which contains the details of allotment. And if you violated any of the provision, you'll get penalty. Next is, again they have given you the procedure, they'll repeat it again. So whenever a special resolution is taken, along with that you have to give an explanatory statement. Explanatory statement will contain all the basic details for the issue. Maximum persons to whom it can be issued, so shall not be issued to more than 200% in a year. While calculating 200%, two kind of persons are excluded: employees and QIBs. Okay. Now coming to the prescribed form for private placement, PAS 4, private placement come offer application money, application letter. So as I told you, PAS 3 very very important, and PAS 5 is a record or a register of private placement. Okay, then comes return of allotment. So you have your return of allotment, private placement, letter of offer, and a register of private placements. Now coming to bonus shares, section number 63. So we have finished section number 62. Bonus shares is called as capitalization of reserves, where from the reserves it's turned into share capital and the shareholders get these for free of cost, but in reality in the company has deducted the reserves and from that they have added in the share capital. Okay. Now section number 63 has 3 subsections, okay, all of which is important, very very simple. First is the bonus issue. The company, from where can they give the bonus shares? Sources for issue of bonus shares. For example, if the company has to issue free of cost, but someone will have to pay for it. So one is you can use your free reserves, as I told you. Or if you remember section number 52, subsection 2, it says that you can use it for security premium account also to issue bonus shares. And lastly, capital redemption reserves. Okay, these 3 are the sources for bonus issue. Then comes, no bonus issue shall be made capitalizing the reserves created by revaluation of the assets. Now, if I revalue the assets, for example, my asset was 30 lakhs, now it has become 31 lakhs. With that, 1 lakh is just a notional profit, it's not a realized real profit, and from that you can't give bonus shares. Clear? So bonus shares can be given only from these 3 cases. Now the conditions. What are the conditions for issue of bonus shares? Very very simple. Any kind of issue is there, you require mandatorily a special resolution. Only for DVRs, government has made it after amendment, ordinary resolution. Authorized by the articles, it should be recommended by the board. Company should not have defaulted, and partly paid should be made fully paid up shares. Then only you can issue bonus shares. No bonus shares in lieu of dividend. So many times they ask in the exam that the directors had issued bonus shares, now they want to give dividend, or the directors had issued declared dividend and now want to give bonus shares. So the answer is you cannot give bonus shares in lieu of dividend or dividend in lieu of bonus shares. For example, if I'm telling you I'm going to get for you a car, then I can't give you bike. So give what you've promised. So if the company has promised bonus shares, they have to give bonus shares only. Procedure for bonus shares, again I told you, very, very simple. Articles. Now special resolution is there. So all those points will be there. Same points will be made. Okay. So you can read up, make one standard procedure. PAS 3 will be standard for all kinds of issue. Now coming to sweat equity of shares. Very, very important. Section 2, subsection 88, section 54. Both of them are important. Sweat equity of shares. Now what is sweat equity of shares? If you go to see the definition, now I'll explain you the meaning in very clear terms, you will understand. Sweat equity of shares. These are equity shares issued in lieu of service. In lieu of service. Okay. Now let me explain what the definition says. If you understand this, you will understand the entire concept. Now this is the company, okay, and this might be a employee of the company. This will be a employee of the company. What happens is, the employee has developed some software, intellectual property rights, value addition, some kind of know-how, patent he must have had. So company says, give me that IPR. Against that IPR, I will not give you cash. I will give you shares. Equity shares. Makes sense? Yes or no? So can I say this share is called as sweat equity shares? Just the name is sweat equity to show that they have not got cash. The employee has given IPR. Rest equity shares are, sweat equity are in par with equity shares, same rights, or everything is same. Okay. Now, how do they word it? They say is equity shares issued by the company. So company has issued to the employee for consideration. Consideration is other than cash, for providing technical know-how, value addition, or whatever name called. Clear till here? So what do you mean sweat equity shares? Okay. And then they tell you who is an employee. Employee could be a permanent employee, director, or an employee, whether he is in or outside India. Now this was a new part, whether even if I want to issue sweat equity to a person who is working abroad, that is also fine. So this is the definition. Equity shares means equity shares issued by company to directors or employees at a discount or for consideration other than cash, for providing know-how, intellectual property, value addition by whatever name called. Okay. Now what is section 54 then? Section 54 gives you the conditions for issue of sweat equity. Which kind of resolution? So can you all tell me in which kind of resolution is needed for sweat equity? Please put in the chat box. What kind of securities are issued in case of sweat equity? What kind of resolution is needed? What kind of resolution is needed for sweat equity? Quickly, I'm waiting. Very good. So special resolution is needed. The resolution should clearly mention all these things. Okay. And if it is a listed company, it will have to follow additional sweat equity regulations, rules. Okay. And company where it is not so listed, it will have to follow the government rules only, like this rule. holder of equity shares will be ranked in pari passu with other equity shares. So sweat equity shares and regular shares are one and the same. Explanatory statement will contain all the details of what is the purpose, etc. Details to whom it is issued. Then comes validity of special resolutions authorizing sweat equity. Now again, we had done 12 months, that within 12 months of the resolution, it should be allotted. Okay. If it is not made within 12 months, then a fresh resolution will have to be passed. Limits on issue of sweat equity. So very, very important. Within how much time? So it says 15% of paid up equity share capital or 5 crores, whichever is higher. Okay. So how much sweat equity can be issued by the company? So company cannot issue too much equity shares also, up to 5 CR or 15% of paid up equity share capital, whichever is higher. The issuance of sweat equity in the company shall not exceed 25% of the paid up capital at any point of time. So this is 15% in a year. So at any point of time, it will be max 25%. So to 15% this year, 15% next year, not allowed, because collectively at any point of time, the maximum number of sweat equity that can be done is 25%. Okay. And for startup company, the government had given a benefit instead of 15 and 25%, may issue sweat equity not exceeding 50% of the paid up capital up to 10 years from the date of incorporation. So for startup companies, where we believe that there is a lot of risk, so and the owners also don't have much money, so then they can choose to give some equity, sweat equity. So up to 50% they can give. Okay. Sweat equity shall be locked in for a period of 3 years. Valuation aspect. Now valuation report should be done. For example, they will value the nature of consideration given, what kind of benefit has been given, what is the value addition, their know-how, etc. Sweat equity for non-cash consideration. Okay. If it is in the form of an asset, then it will be put into the balance sheet. But if it is not an asset, then it will be put into the expense. It will be expensed out. This will be according to the standards. Sweat equity forming a part of managerial remuneration. So will the sweat equity shares be considered as a part of your managerial remuneration? For example, if the maximum remuneration allowed is 10 crores and I am issuing certain amount of sweat equity, will that be coming here? So the answer is it will be treated as a part of your managerial remuneration if the following conditions are fulfilled. Now very simple. If the sweat equity shares are issued to directors or managers, so if it is issued to employees, it will not form a part of managerial remuneration, because managerial remuneration entire topic only applies to directors and managers. And second, it is not of the consideration that the company has got for the equity shares is not in the form of assets, but is in the form of some expense, or it is some of not that big asset that it will be put into the balance sheet. Okay. Then sweat equity and compensation aspects. If the sweat equity is not issued pursuant to an acquisition of an asset, then in respect of that, the accounting period shall be treated as a form of compensation to the employees. Now this is same, that if it is issued in the form and it is in the form of an asset, or it is not in the form of an asset. So if the sweat equity issued is against what it is issued, if it is following an asset or it is not following an asset. Board report should disclose all the facts, and you have to maintain a register in SH3. Now coming to another topic, which is alteration of share capital, buyback and reduction of share capital. Okay, so we'll quickly go through this also and finish it off. First is alteration of share capital, section 61 SH7 and section as per section 64 SH7 needs to be filed. Alteration means making change. Now change could be if I'm increasing my share capital, or I'm consolidating it, or subdividing the number of shares, or converting fully paid shares into partly paid share, into stock into shares, or shares into stock, or cancelling the shares. All these things will be treated as alteration of the share capital, and the company will have, if it is authorized by the articles, will alter it with the help of an ordinary resolution. Quickly, so what does this mean? That alteration of share capital, alteration of share capital given under section 61 subsection 1. Okay, what does it talk about? Let's see. First is, they have given you 5 points, A, B, C, D and E. If I'm increasing my share capital, then I'm bringing changes. I need to inform ROC in form number SH7. Okay. Now, if I am consolidating my shares, that is, one share is of 10 rupees. So I consolidate 5 shares. If you're holding 5 shares, then you will get one share of 50. Or I am subdividing the shares. So again, I'm bringing some changes in the share capital. So if one share, so let's say one share is of 50 rupees. Okay, so 50 rupees, one share of 50. So if I want, I can make 10 shares of rupees 5. Okay, of rupees 5. So when I go do this thing, 10 shares I'm making of 5 rupees. So I'm subdividing it. Here, what I'm doing is I can club all my shares and I can make it one value. So let me explain. Okay, so what is consolidation and subdivision? So one share of rupees 50, value is how much? 50 rupees. Now company realizes, like companies like MRF etc. have one share of 50,000 above. So then we realize, hello, yeah. So what we need to do when one share is of huge amount, let's say 50 rupees is a huge amount. So then we can make it 10 shares of rupees 5 each. So the value will still be rupees 50. So from year to year, when I go, one share I break it. Okay, so is my audio clear now? Okay, am I audible? Am I audible now? Am I audible? Okay, I'm just waiting for your confirmation. Okay, great. Great. So let's continue. Okay, so the thing is, if one share is of 50 rupees, the value is 50. Company might realize that 50 rupees, the price is too high. In the market, people are not paying 50. So what they can do is they can choose to subdivide. They will break it, divide the share and make it 10 shares, and one share will be of rupees 5. So 5 rupee shares will be more liquid and it will trade much faster. However, if the company ever realizes that no, they don't want such small amount, then they can consolidate. So they can consolidate 10 shares into one and make the share price of one as rupees 50. So this they can do. So company, if they want to consolidate or subdivide, then is turning your shares into stock. What do you mean by turning your shares into stock? If one share, you might be having 100 share certificates. You can surrender them and make it as a stock certificate. where one certificate will be representing 100 shares, or cancel shares which are not taken up by anyone. So all this is treated as share alteration of share capital. You have to inform the ROC in SH 7 by passing a ordinary resolution. Okay, so these are the details. So here section number 64 says that you have to file SH 7 and do that. Now coming to the next important topic, which is buyback of share. Now when a company purchases its own securities, it is called as buyback. Now why will the company purchase its own securities from the public? Now it is possible that the company has excess funds. These funds, they don't know where, no project is there in the market. So they can choose that, if someone wants, they can give their shares, we'll give them their money back. So that is called as buyback. Second purpose why buyback can be done is if I feel that there is a takeover threat. Some other person, third party will come and give an offer to my shareholders and take the shares of the company. So I don't want that. So then I am telling my shareholders that don't give anyone else, give me the shares. I am ready to buy back, but don't give to others. Third reason is to Okay, so the next purpose is when the company wants to improve their earning per share, as the number of shareholders will reduce on buyback. So less number of people, the profit will be divided among those less people. So hello, okay. So the next is the sources of buyback. From where will we pay off all the shareholders? From where the company will have money to pay off all the shareholders? They can use this free reserves, they can use the security premium account, or they can use of proceeds of any other issue. Okay. Now coming to the authorization, the board of the articles of association should authorize the buyback. Quantum of buyback, this you can mark it as most important. Even from exam point of view, they ask the question. So what is the maximum amount that a company can buy back? So please note it down and take the section numbers for buyback also. So buyback section number, section 68, 69, 70. 68 gives you the conditions for buyback. 69 says transfer to CRR, and 70 talks about prohibition of buyback. Clear till here? So these are the important section numbers that you should remember. Now in this they have given you what is the maximum amount of buyback that can be done. So how much the board of directors can do a buyback, and how much is the company they can do the buyback, shareholders. When I say company, means the shareholders. So board of directors can buy back 10% of paid up equity share capital of company. Clear? Plus free reserves. 10% of equity paid up capital plus free reserves. Plus free reserves. So we will have to find out how much is the paid up equity share capital and take 10% of it. How much the shareholders can buy back? If the board of directors want to buy back, they can buy back till this limit. But if at any time the company wants to buy back, the board of directors want to buy back beyond this limit, then they will have to go to the shareholders, and the shareholders can buy back 25% of paid up, not just equity capital, equity plus preference also. So we'll call it as paid up capital of the company plus free reserves. Clear till here? So this is the maximum amount. The shareholders by special resolution. So the shareholders will have to take a special resolution for this. Okay, can buy back up to 25% of the paid up capital. Now paid up could be equity plus preference plus free reserves, and at any point of time the company cannot buy back 25% of equity shares greater than 25% of equity shares. So the first limit is 10%, second limit is 25%, third is what they are saying is, in respect of buyback of equity shares, the reserve of 25% shall be construed with respect to paid up equity capital in that financial year. So, okay, so they've given you only this much, first 2 points. So remember, special resolution will be accompanied by explanatory statement, which is a very simple. Explanatory statement will contain all the details. A letter of offer. Now we are going to the important points, that is your SH 8, 9, 10, 11 and 15. 8 says these are all for buybacks. These are all for buyback. 8 is a letter of offer. So a letter of offer will be given to all the shareholders that do they want to buy back, then give their reply. Then the company will have to also give a declaration of solvency. A declaration of solvency, the board of directors will have to declare solvency, that they have the money to do the buyback, they will be able to pay off the shareholders, and the declaration of solvency will be for 1 year. Once they declare that, okay, and declaration of solvency is done, then will come the register of buyback. Register. So you have to maintain a proper register of buyback. Then comes completion of buyback. Once the buyback is completed, SH 11 has to be filed, completion of buyback, and a return of buyback will be in SH 15. So let's see quickly. Letter of offer. Dispatch of letter of offer will be done. Period of buyback. Now it will be for 15 to 30 days. So the shareholders will get minimum 15 days, maximum 30 days to reply. Post buyback debt equity ratio will be 2:1 max debt equity. So if the equity is 1, the maximum debt they can take is 2. Now shares should be fully paid up. The time gap between two buybacks should not exceed. No buyback shall be made within a period of 1 year reckoned. So if buyback has been completed today, for the next 1 year you cannot do a buyback. Time limit to complete the buyback is again 1 year. So within 1 year the entire buyback should be completed. Methods of buyback. From whom you can buy back? One is very simple, from the existing shareholders. From the employees you can do. So I can do a buyback only from employees. I can do a buyback from shareholders, or I can do without a letter of offer. I go in the open market and tell anyone wants, come to the stock exchange website and we are ready to buy back. Declaration of solvency, I told you it will be in SH 9, that within 1 year you will be solvent. The company has to extinguish the securities within 7 days of completion of the buyback. So moment the buyback is completed, the person will come and give his share certificate, take his money and go. Company, this share has to destroy this share certificates within a period of 7 days from the date of completion of buyback. Prohibition of buyback. Now your company is prohibited from making a further issue of shares. Okay. For example, company did a buyback today. Now moment the buyback is done, again company wants to issue new shares. So they cannot do, okay, within a period of 6 months. 6 months they are saying, now wait, you just did a buyback, now don't go to issue. wait 6 months. However, company can go within 6 months also and make a further issue for bonus shares, for warrants, for converting their shares into warrants, for stock option schemes, sweat equity schemes, conversion of preference into equity. All this is allowed even within 6 months. Register of buyback will be maintained in SH10. Return of buyback shall be in SH11, and a certificate that signed by 2 directors that the buyback has been completed in accordance with the law will be in SH15. So SH11 is a return to be filed, return of buyback. Okay, return of buyback, and here it is with the signature that the buyback has been completed as per law of 2 directors. Punishments. Then comes section 16(9), transfer to CRR. So how much ever has been bought back, that much amount has to go to CRR account. Prohibition of buyback. So buyback cannot be done through a subsidiary, through an investment company, or if a default is subsisting. However, if the buyback is not prohibited, the default has been rectified and a period of 3 years has been lapsed from the date of the default. So if a default is there in repayment of deposit, okay, or any interest thereon, or on any preference shares, then they cannot do a buyback unless they rectify it and 3 years has passed. Now we are coming to the next concept, which is called as reduction of share capital. Next we are coming to the concept of reduction of share capital. Okay, so let's see. Section number 66. Now under section 66, it is called as reduction of share capital. Reduction of share capital. Now let's understand how it is. Okay, first is reduction of share capital could be of 2 kinds. One is which requires NCLT approval, National Company Law Tribunal approval, and the other one does not require NCLT approval. Clear till here? Does not require. Which requires NCLT approval is all the cases falling under number section 66. Which does not require NCLT approval is called as diminution of share capital. Diminution of share capital. So whenever we say that reduction of share capital, we are actually talking about section number 66, which is NCLT approval based. Because it does not require NCLT approval, we have a special name called as diminution of share capital. In both these cases, you will see that the share capital of the company is reducing. Now whenever the share capital is reducing, it is not a good sign, because the company's net worth is going to come down, the creditors will have lesser amount to rely on, and company has less amount in its pocket. So we are going to talk about section 66, which require NCLT approval. So first is article should authorize, special resolution is needed, and plus NCLT approval is needed to complete a reduction of share capital. Now the modes, how do you reduce it? So one is reduce the liability, okay, of the share which has not been paid up, or reduce the liability by cancelling which has been lost, or pay off any paid up capital which is in excess of the company's bonds. So let's see all these cases. I will give you an example. So we are talking of section number 66. Section 66. Okay, section 66. So first they are saying, one is you are trying to reduce liability which is unpaid. Okay, we are talking about reduction of share capital. For example, you had to pay me 30,000. I say don't pay me 30,000, just pay me 20,000. So company has, if they approve this, it will amount to reduction of share capital, because share capital we were expecting 30, now we will only get 20. So this is one mode of reduction of share capital. Second is cancel shares which is lost. So lost assets. For example, if the building has been destroyed or the stock and trade has been destroyed, okay, of the goods of the company. So the asset side has come down. So this we need to balance the balance sheet now. The assets are no longer there. So lost assets from asset side we will remove. So liability side we will say, tell the shareholders, listen now, share capital will be reduced. At the time of winding up, you will not get so much money. And the third is repay excess amount. Repay excess capital. For example, you have paid up 30,000 and I realize that 10,000 I don't need. So 10,000 will be repaid. So in all these cases, company reduces its share capital. Okay, now it is obviously not a good sign when the company is reducing its share capital. Okay, so this is mostly when companies are into some financial difficulty where all these things has to be done. So the tribunal, when you go to the tribunal, it will ask all the authorities and the registrars, SEBI, etc. if they have any objection. The tribunal will then pass, after listening to all the parties, will pass an order. Okay. Liability of the member. A member of the company, past or present, shall not be liable for any call to the amount which has been so reduced. For example, if the amount was 10 rupees initially and company has reduced it to 8, so the liability of the member of that shareholder will also reduce. If he had to pay 10, now he just has to pay 8. Diminution of share capital is also reducing the share capital but does not require NCLT approval. Examples of this is where we understand, okay fine, the share capital reduced because company must have done a buyback, company must have redeemed its share capital, or some order of court must have come, or people have not taken up the shares, or it has been forfeited or surrendered. So in all these cases it is called as diminution of share capital. So surrender of shares, forfeiture of shares. Okay, then they given you, now they will talk about transfer transmission, the last part of the chapter. Very, very simple. I'll just take you directly to the provisions. Okay, so here we will go just to the main important things. The distinction is from this topic party, they always most commonly ask the difference between transfer and transmission. So when I transfer the shares, it is voluntary act. During the life of the person, on transfer, stamp duty is required to be paid. Okay, instrument of transfer is there, that is a transfer deed is there, and stamp duty is to be paid. Okay, and consideration will also be there. For example, if I am transferring it in your name, all these things will be there. When it is due to transmission, that is on death, insolvency, etc., by operation of law, then in such case no transfer of instrument is required. It will be done on death or insolvency of the party. Since it is on death and involuntary, no stamp duty is to be paid, and no stamp duty since no transfer deed is also there. So I think this is it. Okay, another part you can do from this topic is forged transfer. Okay, forged transfer, this you can mark it as important. Forged transfer is when you forge the signature of the transferor. That time it is a nullity, it does not matter, and if the company has on basis of the forged signature transfer the shares, the company will have to compensate to the shareholder. So that is it from this part. Okay, and we are done with the chapter. So that is it. I'll see you all tomorrow again around 7 PM with SLCM, the takeover code. Also do share it with your friends and do like the video and inform your friends as well. Okay, that's it for today. Good night everyone. Thank you.